requirement for showing a heightened need for self-defense. That was the teeth of these permitting laws.
Because they like the outcome of the policy, the banning of a piece of plastic.
Post-Bruin challenges have succeeded in lower courts. The opinions and reasonings therein have been grossly mischaracterized.
Obviously they're gone, but will be an inspiration for us to do more. I'm not going to sign this bill into law.
And within less than 15 minutes, you can walk out the front door here with a rifle or a shotgun.
A federal judge recently dismissed the Texas suppressor freedom case, which sought to ban the NFA and ATF from regulating suppressors. Lack of standing. The Texas suppressor freedom lawsuit sought to eliminate the National Firearms Act and ATF restrictions on products created in Texas, specifically suppressors. The case, previously known as Paxton versus Dittelbox, was determined on cross motions for summary judgment. All indications coming out of the hearing suggested that things didn't go well for the Pro 2A side. This was later confirmed by an order from the federal district court judge who granted the ATF and the government's motion for summary judgment, resulting in the dismissal of the case due to a lack of standing. However, the judge's ruling appears to be cop-out, a common occurrence when standing is used as a reason to avoid reviewing controversial issues. The court ruled that none of the individual plaintiffs had a concrete injury to meet the standing requirement. Furthermore, the court held that Texas could not stand in the place of its residents to sue the government regarding the application of the NFA to suppressors made in Texas. To provide some context, this lawsuit arose from Texas House Bill 957, which aimed to exempt all suppressors made and retained within the state from federal regulation. The claim behind this law was that such items, being exclusively made and sold within Texas, do not fall under interstate commerce and thus fall outside the purview of the ATF's federal regulation. Texas, along with individual plaintiffs, filed the lawsuit against the government, leading to this case being submitted to a federal court on cross motions for summary judgment. Arguments were presented last month, and the court had to decide whether to grant the plaintiff's motion for summary judgment, rule in favor of the individual plaintiffs in Texas, or grant the government's motion for summary judgment in favor of the ATF. In the end, the court ruled in favor of the government, stating that the plaintiffs lacked standing to bring the lawsuit. The judge emphasized that legal actions cannot be brought solely on the grounds of being displeased with the government's actions or laws. Federal courts are only constitutionally empowered to resolve actual disputes. All the requirements for standing. There are 3 prerequisites to standing. First, there must be a concrete harm suffered by the plaintiff that is not speculative or hypothetical. Second, there must be causation or a reasonably traceable link between the harm suffered by the plaintiff and the defendant's conduct, in this case, the government. Third, there must be redressability, or essentially a likelihood that the requested relief will remedy the alleged harm. Without standing, a lawsuit cannot be pursued. The judge ruled that while each plaintiff was correct that the government has a history of prosecuting those who illegally possess silencers that are not registered, these plaintiffs failed to present any evidence that they actually did so or that they had engaged in any other prohibited behavior. They also failed to establish that they had been threatened with prosecution or that it was likely that they would be, and criminal law doctrines prohibit convicting people for merely harboring criminal intentions. Showing evidence of threats. Regarding the absence of standing for individual plaintiffs in the case, the judge's ruling emphasizes that they fail to allege a substantial danger of prosecution based purely on their desire to participate in an activity that the government has previously prosecuted. This is because they wanted to engage in an activity that the government had before prosecuted. According to the judgment, the individual plaintiff's fear of prosecution is at most hypothetical or speculative, neither of which satisfies the standards for Article 3 standing. Consequently, the judge ruled that the individual plaintiff's claims lacked standing. The judge goes on to explain that in order for the individual plaintiffs to have standing in the case, they must argue that they either own an unlawful silencer or engage in some other form of forbidden conduct that is asserted to be illegal by the ATF. In addition, the court notes that the plaintiffs may be able to establish their standing by demonstrating that they have been target of direct threats made by the ATF in relation to the production of homemade suppressors. According to the judge, in order to successfully challenge a criminal statute prior to its enforcement, a party must demonstrate that there is a reasonable risk that they would suffer a direct injury as a result of the statute's execution. However, the judge is of the opinion that it is not necessary to show that the defendant intended to break the law in order to establish standing. Instead, the judge says that in order for a plaintiff to have a standing to sue the ATF, they would first have to participate in behavior that is considered illegal. This would be equivalent to a plaintiff falling on their own sword for the sake of the Second Amendment cause as a whole. Importance of concrete injuries. The judge went on to explain in his ruling that the burden of proving standing cannot be removed simply by asserting that the statute in question violates the Second Amendment and infringes upon the rights in question. According to the judgment, the individual plaintiffs have not made any effort to submit an application to manufacture and register a silencer. Assuming that their argument that the conditions violate the Constitution is accurate, it becomes irrelevant whether an application is ultimately accepted or rejected. In either of these two possible outcomes, the plaintiff can end up getting hurt as a result. In the event that an application is mistakenly denied, the government will have deprived the applicant of a silencer, which will result in injury. On the other hand, even if an application is granted, the plaintiff may still suffer damages because they will be required to go through the process and pay the tax. However, the judge maintains that the individual plaintiff's desire to produce a silencer in violation of these rules is insufficient to prove that they have been materially harmed by the procedure that they are attempting to contest. In this particular case, the judge has taken a position that seems to imply that in order to sue the government for engaging in such unlawful practices, a person must first put oneself in jeopardy of being prosecuted for significant criminal offenses. In essence, individuals are required to put themselves through the precise procedure that they intend to question. The next question the court addresses is whether the state of Texas has the legal right to bring this lawsuit. It concludes that it does not. The judge ruled that according to statements made by the state of Texas itself, the state cannot sue the federal government on behalf of its citizens in an effort to block the application of the National Firearms Act to suppressors manufactured in Texas. Frustration over suppressor lawsuit dismissal. The only purported connection between Texas and the GCA regime is a state act in Texas that exempts silencers from the application of federal law. The Supremacy Clause of the Constitution determines who emerges victorious from this contest. The state of Texas wants to ensure that every one of its inhabitants retains the right to make agricultural silencers in their own homes. It is impossible to imagine a more personal interest than the capacity to better hear a house burglar in the middle of the night and fend them off with the assistance of a handmade silencer. This is a skill that can be learned quite easily. It is not permissible for the state of Texas to act as a volunteer litigator for the personal interest of its citizens. In order to defend the individual rights of its citizens with regard to Second Amendment, the state of Texas is considering filing a lawsuit against the federal government in its capacity as the parent organization of the Patriot Movement. According to the judge, there is no longer any doubt about this matter. Now, some people might find it rather annoying to read this particular section. The judge makes a remark that reads as if he is acknowledging the significance of a person having access to homemade suppressors for the sake of self-defense and the right to protect themselves using these kinds of devices. But then he claims that the state cannot aid the people in defending their Second Amendment rights while engaging in this legitimate behavior, or what I believe should be considered lawful behavior. This is a contradiction in terms on his part. Earlier, he stated that the only way the individuals here could essentially sue the government is if they first opened themselves up to the possibility of being prosecuted for a criminal offense. Following consideration of all this evidence, the court decides to approve the government's petition for summary judgment and to throw out the case in favor of the ATF. Ongoing possibilities and potential appeal. However, this investigation is not even close to being finished. There are still two different outcomes. Going forward, the state of Texas has the ability to refile the case with plaintiffs who are willing to expose themselves in the manner that the judge directs them to, possibly even with plaintiffs who have a concrete claim of intent to make a first ever Texas suppressor or who are the target of potential threats by the ATF or the government against homemade suppressors. However, if the state chooses not to refile the case will be dismissed. Despite this, the state of Texas will almost certainly file an appeal of this decision. In the event that the lower court rules in favor of the government, an appeal will be filed with the Fifth Circuit, where it will be heard next. The case will then be reviewed by the Fifth Circuit, which will decide whether or not the judge made a mistake in dismissing it owing to a lack of standing, which would have made the loss less disappointing. The judge in this case did not want to deal with the contentious topics of suppressors, NFA items, interstate commerce, and what the Second Amendment protects in terms of homemade suppressors. Thus, he chose the simple path and the easy way out that most judges take by simply declaring that this case lacks standing. Regrettably, however, that this is where the case stands at the moment. That's all for this video, folks. See you next time.